Well, hello, hello, hello. Happy Tuesday that feels like Monday with all the confusion that comes with it. Glad to see you guys here on a recap of another day in the Murdaugh trial. This is the trial that never ends. Well, it was a day. It was a day. But we have some developments we got to talk about. We'll do this real quick. We're going to run a very, very brief intro just so that people know that we're here, and then we'll kind of get into it. So I'll see you guys on the back end of this. Again, this one's real short. All right. So day number 1,552 in the Murdaugh trial. We are still going. Just kidding. We are at day number 21. And today we got kind of the defense's case in chief that began in earnest. To say that the defense had their case in chief start on Friday, when all we had to testify on Friday was essentially two witnesses that were very quick, one of which said that they determined the time of death by putting their hand in the armpit. That works. To those of you asking if we're going to have a surprise rant from Runkle, we're not. Runkle's working. He took time off a minute during the workday to play his thoughts. I might pull those up as a separate little video, just as we get to some of the antics in courtroom. But yeah, so coming off of a break after a weekend, generally speaking, the attorneys are pretty anxious getting in there. They want to get started, but we had some hiccups as we began trial today. So the first hiccup was that we've lost another juror. Another juror has reported to have essentially feeling illness. They went to the doctor, and this is kind of the risk with these long trials. And one of the things and one of the considerations the judge gives when they're trying to determine how many alternates they're going to need for the trial is the time that's been estimated for that trial. In this case, the attorneys, both sides, told the judge they were estimating a 3-week trial. Well, that factors into the calculus for the judge in determining how many alternate jurors they're going to need. Because at some point in time over these lengthy trials, you start to lose jurors because of illness, because of conflicts, because of things they can't get out of. Well, right now we are entering into, it's week 5. So we're 2 weeks beyond the date that we thought we were going to end this trial, and 2 weeks beyond the date that these jurors anticipated sitting in that jury box. So we have another juror that has been excused. And then we've brought in an alternate to replace that juror. So we're down to 2 alternates now. Both the prosecution and the defense said that they wanted to go forward today and begin working on this and to essentially try to fly through some of the remaining testimony to make this not a 7-week trial, but I cannot see how it's going to be done in 5 weeks. The defense said that they are going to try and finish this by the end of the week. Jim Griffin said that he really anticipates they're going to be done by Friday, but then we have the state's rebuttal case. And since we've got remarks from an expert on behalf of the defense, I imagine the state's at the very least going to recall at least one of their experts, if not 2, to try and clarify or make their position known before they go to closing arguments. So I think that there's no way this is a 6-week trial. This is now a 7-week trial, and that's before it gets turned over to the jury for deliberation. So as we go forward, I want the chat. This is kind of my message to the chat here. Please try to remain respectful in the chat while we're discussing this particular case. The prosecution had essentially 4 weeks to put on their case in chief. And that presented a great deal of evidence that the prosecution believes weighs heavily in favor of Mr. Murdaugh's guilt. At the end of the prosecution's case, every person should feel that Mr. Murdaugh is guilty of the crimes with which he is accused. And then you begin the defense case chief in earnest. This is a very difficult place for people to be because people have opinions already formulated based on the evidence. And it's difficult to kind of take a step back and view those opinions in the context of additional information being poured in. So to the extent that we can, let's try to view this analytically and respectfully, even though we had some disrespectful remarks. What I will say is that there is very, 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 for a trial that began on for a trial with murders that began on a hunting property, we have seen more disparagement of animals than I think that we would all enjoy, including Bubba, whose name was very, very seriously besmirched, a rooster who found themselves in the height of a war between the dogs and the chickens. And at this point in time, now we have a horse that has been dragged into the courtroom, laid down on the courtroom floor, and beaten to death by the prosecution and the defense. So yeah, that's kind of how we're beginning this. And I did see something that made me chuckle right before starting, which might have led to the later start. And it was this. Y'all know I like to make stuff. And Avery Wilkes has been in the courtroom every day reporting on this case. He's done great live tweeting on the case as it progresses. But someone crocheted Bubba and his chicken. And while this is not full redemption for Bubba the Yellow Lab, I feel like this is a pretty good place to start today's stream, doing a recap on week 5 of a trial. So I thought it was funny. I want to share that with you before we get into the serious subject matter. And with that out of the way, why don't we go ahead and start talking about some of the fireworks at the very beginning of the day. After we had the juror dismissed, we then went straight into an issue of controversy that the judge wanted to highlight. And the judge wanted to highlight, let's see if we can begin this properly. Do we know what we're doing? We do. At the very start, with Mr. Griffin having to do with an article that was published on the Washington Post. So let's see what has to happen in this beginning. I have some thoughts, but we'll get to that at the end.
Secondly, I've been receiving over the past 2 to 3 days emails concerning a social media post by Mr. Griffin commenting upon witnesses' testimony and quality of the investigation by the state. And it appeared on my Twitter feed this morning. Mr. Griffin, is this part of your defense strategy or?
Your Honor, all I did was retweet an article that was published in the Washington Post. I didn't put any comment. I didn't make any statement. I just retweeted the article that's in the newspaper. That's all I did.
You know, we had an NBA player who retweeted an article, professional basketball player who retweeted an article that resulted in him being suspended from the NBA for about 10 days. And
we also have a celebrity that retweeted an article that resulted in a 6-week defamation trial in Fairfax County. So retweets, that's you're publishing stuff, but we'll get to that in a second.
It cost him about $10 million in salary. So
$10 million
tweeting is the same as, to some, as if your tweet. It appeared, I didn't know that, well, I mean, I'm not a Twitter friend of yours, but it just appeared on my, under Twitter. First thing up this morning was you. You know, we had the lawyer who had a similar name to, a person with a similar name to our lawyer witness, and it was someone else by the same name. In your interest, in your instance, it's your name and your picture. So
I did retweet the article, no question about it.
Yeah, well, I've been reviewing Rule 3.6 regarding that, whereas the rule does not specifically state that that lawyers are prohibited from criticizing witnesses during the course of the trial or commenting on a case that they're actively participating in, I think it goes against the spirit of the law, of the rule, and it doesn't pass the field test. So that's.
So I'm going to bring this quote up. Laura, thank you very much for the question, because this was something that I was wondering about as well, or kind of, I know people are kind of thinking about it as well. Let me pull up the tweet as I answer this question. Okay. So let me do this. We will stop sharing briefly on this one. Then we're going to go ahead and pull up the tweet itself and see if we can't take a look and see what the heck we're talking about. This is the tweet. So as many people correctly pointed out, this is not a retweet. A retweet essentially doesn't show up on your feed with a comment above it. It just shows up that you retweeted something. We can actually go back to Mr. Griffin's profile here, right here. Mr. Griffin, he acknowledged it was him. And you can see it's not a retweet. So he has other tweets here, but this is not a retweet. He just looks like he went to the Washington Post and tweeted it out and essentially either copied the headline because it looks verbatim off the headline, or the headline auto-copied. But either way, he shared the article. So he went and saw the article and shared the article. Now, the question that was asked by Laura was essentially, how would I feel about this? Or what were my personal thoughts about this? The judge made it clear. This is not out of bounds. This is not expressly prohibited by the rule. Attorneys operate within the confines of the rules with which they're given. You will see a lot of cases where there's a gag order that's placed on the case by the judge from the beginning of the trial. The judge will enter a gag order and says neither party is permitted to speak to the media during the course of this trial because there's been so many media leaks that they're concerned the jury is going to get it, or they're concerned they're going to see it. Okay, that did not happen in this case. So right now, you're back to the de facto rules, 3.6. Rule 3.6, South Carolina Rules of Professional Procedure. Let me see if I can pull that up. Rule 3.6, South Carolina Rules of Professional Conduct. And I'll see if I can get that real quick because I actually wanted to pull this up. There we go. So I'll pull down this one. Then we will pull up the rule itself, and I want to walk through that rule briefly. So Rule 3.6, coming from South Carolina Rules of Professional Conduct. Speaking to trial publicity, a lawyer who is participating or has participated in the investigation or litigation of a matter shall not make an extrajudicial statement that the lawyer knows or reasonably should know will be disseminated by means of public communication, will have a substantial likelihood of materially prejudicing an adjudicative proceeding in the matter. It's this second part. This part here will have a substantial likelihood of prejudicing an adjudicative proceeding. If you know the jury is looking at the newspaper, for example, you can't then say the newspaper says this. If you know that the jury is sitting there messing around on social media or Twitter or has the likelihood of seeing this, you can't really give opinions that might prevent them from rendering a fair and just result. So notwithstanding, so there's a carve out, the lawyer may state the claim, offense, or defense involved and the identity of the people involved, information contained in a public record, that an investigation of the matter is in progress, the scheduling or result of any step of litigation, a request for assistance in obtaining evidence and information, warning or danger concerning the behavior of a person involved. In a criminal case, they can release the identity, residence, occupation of the accused. If the accused has not been apprehended, information necessary to aid the fact, time, and place of the arrest, the identity of investigating and arresting officers. Then, last caveat, catch-all. Notwithstanding paragraph A, a lawyer may make a statement that a reasonable lawyer would believe is required to protect a client from the substantial, undue, prejudicial effect of recent publicity not initiated by the lawyer or the lawyer's client. Then it's limited to information as is necessary to mitigate the recent adverse publicity. So that's the rule. So what you can see by that is that we are not really within the express definitions of this particular code section. That brings me back to the question that was asked of me. How would I feel about it? How would I do it? I am not Mr. Griffin. I am not a criminal defense attorney representing my client who's accused of a crime. I'm a domestic relations litigation attorney. I try cases in front of judges. Most 99.9% of my cases are going to be bench trials. That makes the adjudicator of the facts the judge. I am very careful about what I talk about when it comes to people in the judiciary because of that fact. I don't want people to misconstrue my statements as being a statement against the process itself, or even worse, that statement that I would make publicly might come back and hurt the clients that I represent. Do I think it was a violation of the rule? No, the judge didn't say that either. The judge said it might have violated the spirit, but not the actual rule. Would I myself engage in this? No, because I think it would have a prejudicial effect on the impact on my client. To the extent that a judge woke up one day, looked at my Twitter, and saw some comment that I made about that judge or a similar seated judge in their position, I would not want the judge reading that to then bring that into the courtroom or thoughts of that into the courtroom. So, do I think that it was unlawful? No. Do I think it was stupid? Yep. But the same thing as Tinsley. When Tinsley basically comes out there and gives money to another witness while they're there, GoFundMe, yeah. Was it illegal? I didn't find any law that said it was. Was it foolish? I think it was. And I think that those two things can just be true, and we don't have to have a problem with that. So that was one of the big to-dos about today. In either event, I know that that's kind of a tangent. It is and it's not, because people have been offering opinions about the judge, about the attorneys in the case, et cetera. And I have to be careful with this stuff because I do still practice. And the last thing I want is for a judge that I'm in front of when I have a client that I'm representing to take an adverse look or a view at my client that was caused by something I did in the media or publicly. So that's why I like to be careful. But again, I am not Mr. Griffin. My client is not on trial for murder. They're different. So, yeah. Anyways, did that carry over into his examination of the very first witness in the trial, who was none other than Buster?
The general public. Anything else before?
Tell the jury a little bit about yourself. Where you born? Where you raised? Where'd you go to school?
Right. So my name is Buster, 26 years old. I live in Hilton Head Island, South Carolina. I was born in Savannah and lived in Beaufort for about 2 years. When I was a little child, we moved to Hampton in about 2000, and I grew up in Hampton, went to Wade Hampton High School. And after high school, I went to a small college in Spartanburg called Wofford.
I'm talking, my mic's been muted. That's awesome. I wanted to make a quick observation here. So I'm going to try and repeat and remember what I was saying while my mic was muted while I was taking a drink of water. Alex Murdaugh was sitting there, and I don't know if anyone else observed it, but he was smiling through almost all of this testimony. And the smiling through the testimony, yeah, it's your son that's testifying, but the son is testifying in a murder trial where you are accused of murdering his brother and mother, your wife and son. I don't know that the smile is the appropriate gesture you want to convey. And it kind of was off-putting to me. It was just an observation. I don't know if the juror is viewing it that way. This is my thoughts. I'm being very clear with what my thoughts are. I'm not saying you have to feel the same way at all. It's just really, really different. Yeah. Now, I will say this. There's not a whole lot in the way of testimony that Buster brings to the table that's beneficial or harmful to Alex. I didn't really find that his testimony was as impactful, and I have an opinion on that one. I think both attorneys here were very, very, very cautious around Buster. Buster might have a motivation to say something that's going to help his father, and might say something that maybe he didn't actually remember, or say something that he thinks one of the attorneys wants to hear, or Jim wants to hear. And he might go a little bit further. Now, Jim has to be careful because it might go too far and the statement might not land well. So you have to be really, really careful in what questions you're asking Buster. And it's a very uncomfortable position. So you combine that you've got a witness on the stand who you're really nervous about testifying. And then you have a judge that just dressed you down for social media remarks. And that might lead to some of the questioning and why it felt a little bit awkward, disjointed, slow at times. I don't think we got a whole lot out of this direct examination. So we'll see. But look, I fast forward another 3 or 4 minutes and he's still smiling. It's still an awkward feel to me.
Between you two at times?
Yes, sir.
And what, why?
Well, kind of like I just touched on. So he would use it. He's not very good about putting it back where he found it. I leave it somewhere. I go back and, want to get it and it's not there.
Did
Just smile.
Did you notice, were you aware that Paul got a replacement at some point in time?
No, sir.
Well, you heard about that in the courtroom.
Yes, sir.
Trial. Okay. But up to that point, did you ever see Paul use the replacement?
No, sir. I've never seen a replacement.
So every time in your presence, Paul was using a 300 blackout, which one would it be?
Mine.
There's, I'm not going to pull these guns out, Buster, but there's been discussion and the jury has seen a 12 gauge Spinelli with a Mojo sticker on it. Whose gun is that?
That's mine.
And what's Mojo?
Mojo is a brand of decoy. It's,
Like I said, guys, there really isn't a whole lot here. The only thing that we got out of this was that he wasn't aware that a replacement gun was purchased, that Buster or that Paul would use his gun relatively frequently. And then there was testimony about parking on the grass and the fact that Buster brought this to the attention of somebody after some of the testimony. Well, it wasn't really asked of him prior to that. So I didn't like the cross. So let's see if we can get to some of the cross-examination. Side note, I really did. Where was it? I just had an image pulled up. Where was it? There we go. I need this software. I don't know what software it is. This is awesome. The ability to display full images and then kind of highlight and bring that out. I was watching this morning. I was going, okay, of everything I'm learning from Buster's testimony, it's pretty much that this software is pretty cool. And I kind of need this for my own trials and, or talking about these trials with you guys, because how many times have I wanted to pull out PDF images and go to specific quotes. Buster texts to the normalcy of the text message between the parties and everyone involved and how phone calls would get missed. There was some commentary about butt dials, things in there, commentary about driving. We end up learning that Buster went to Alameda after this incident very early in the morning. The next day went to Alameda. They were all there. Then Buster goes back to Mosell's to shower. Buster was the one that packed. Buster goes to was the one in Moselle that packed Alex's bag. At least that was his testimony. Doesn't remember if he knocked anything, but that at least in theory could explain. Well, the defense is asking that explain why there was a shirt on the ground, why things weren't exactly as they were left. Buster testifies that his dad has things everywhere, clothes everywhere, and all these different properties. A lot of it was leading. A lot of it really didn't get a whole lot of answers to anybody else. If you believed Buster, you believed Buster. That's what it is. I don't think that there was really anything in here that was impactful for either particular party. So let's go on and find where cross-examine takes over. I don't want to see the commentary. We've got people coming in the courtroom. And you guys, I'm not as organized with the timestamps because here's one of the things about the timestamps. I do these streams essentially right after the day ends because I want to make sure you guys are getting my thoughts while I still have them fresh in my brain. It takes me a minute to pull this up. So I try to work through them. So I apologize for the delay. It might seem a little disjointed, but I do want to try and get this out of my brain and out to you guys before too much time passes. And I don't like interrupting a lot of other people's commentary or streams. That said, you guys are going to redirect into Peter, who's beginning his live stream at 8 p.m. tonight. So I did set that up if you guys are still around. So let's see. Right now we're talking about the grass and the parking, and this is where I wanted to kind of take in. So let's back it up by about 5-10 seconds. So we'll talk about the grass. There we go.
So if you look right over here, this is kind of what I'm referred to as like the back corner of the house. And it would basically, you would come around, there's a big oak tree here, you come around it, and then you basically pull up, and you would probably stop the hood of your car right in, right off the back corner of the house.
So it'd be closer to here than over here.
Be about right in here.
So right in here.
Yeah, I mean, because you don't want to pull up super close to it. Yeah, be right out. Okay.
But there was a driveway and paved driveway in here, right?
There is a paved driveway over towards the side of the house.
Okay, and really not many tire tracks. The grass looks good in here.
Yeah, we don't know when the
These
photo was
pictures were
taken.
but it's a little dead right there.
That was my thought when I heard it.
But there is a driveway, right?
There's a driveway.
Okay, you can have a seat there. Thank you, please. When did you first mention that to anybody about parking in the yard there?
What do you mean?
I mean, like, when did you first discuss that with anybody as far as where cars parked at your grandma and granddad's house? When was the first time you talked to anybody about that?
This question was bordering on being a little bit out of line for me. Buster is under no obligation to divulge any of this information to anybody. He is not part of this investigation. He stands separate and apart from the investigation. I thought that this question was kind of implying something it might not have, or it probably shouldn't have, that the second Buster saw that testimony about issues of the grass and where the car was parked, the implication is that he should have immediately ran to law enforcement and told them, this is inconsistent with my thought. I thought that he would have parked on the grass. I thought that was a little bit out of bounds because it's suggesting something to the jury that's really not his obligation to do. Who was questioning him? This is Medders. John Medders was brought in on the prosecution team leading into this trial. People have referred to him as the my cousin Vinny attorney. I find that his demeanor is kind of in that realm. So, yeah, I didn't really like the question. But again, Medders was also nervous of Buster. Both of these attorneys tiptoed around Buster, and because of that, you really don't get anything. So Medders knows that he can't go after Buster because that looks terrible for the prosecution. But he also needs to get a few points. So you can't really pass him on the stand and say no questions. You actually have to get some information out of him. This was very tentative and careful. By people, I mean EDB. No, other people have said it too. He really is, because it's mostly the identical. There is no better impersonation I could think of than that, especially last week when he did the clapping thing. So yeah. All right. Not a whole lot was gained from the cross-examination. And honestly, it felt like today might be a wasted day in court. I really didn't think there was going to be a whole lot until we got to the next witness, Mr. Sutton. So, and this is a good question. I'll pull this out of order. Jan, how would I have cross-examined Buster? Kind of in the same way. I really probably wouldn't have gone after a lot of these questions. Make a couple of foundational points. You weren't there. That's pretty much it. You weren't there. You don't know what was happening that night. might have made the point about the firearm and how he was just speaking to things that had happened in the past, not really what happened that night, about phone calls and the time of the phone calls. And I might have talked about whether he had driven with his father to and from Alameda and whether he drove that speed every single time. I don't know. But again, I don't think you're going to get a whole lot out of this testimony one way or the other, which is indicative of the fact that, well, that is furthered by the fact that the testimony of the son in this case went for a grand total of, what is that? So 132 to 337, 2 hours with direct and cross-examination, I think with a break in between. So you really weren't getting a whole lot from him one way or the other. I just didn't think there was a lot there. So then we get to Mr. Sutton. And let's see if we can't get to some of his background.
Out of Raleigh. When I graduated from Cary High School, I went to North Carolina State University, and I was in the materials engineering department for about a year. In my sophomore year, I transferred over to the mechanical engineering department. And so I was at NC State for my undergraduate from 84 to 88. And when I was a sophomore, I met an engineer. His name's Dr. Charles Manning, who owns a company still in Raleigh. He's passed away, but his company's still there. And Dr. Manning was an ex-professor at State. He's also an ex-NASA engineer. And I worked with him from basically 1987. Then after I graduated, I went full-time with him.
When you graduated with a degree in what?
In mechanical engineering.
Okay,
And
you were working with him.
And I continued to work with him. And then I got a master's degree at North Carolina State University, also in mechanical engineering with a concentration in acoustics and vibrations.
In acoustics and vibrations.
Correct.
Your master's. Okay.
Yes.
And then what did you do?
Well, I worked with him as a consulting engineer, consulting forensic engineer, looking at all different kinds of accidents and failures, about anything that you can imagine. We do a lot of motor vehicle accidents, of course, because there's so many. We look at structural failures, product failures, material failures, about anything that you can imagine. But basically, if there's anything that's based in physics, it's capable of being explained and understood.
And what do you mean by physics?
Well, physics are the laws that govern how things around us, how they behave. You can predict their behavior. If I drop a basketball off of a balcony, I can predict how long it's going to take to reach the ground based on all the different variables. So the laws of physics are there. It helps us figure out how things would happen. So I worked with Dr. Manning for a while until end of 2000. And in 2001, I founded my current company, which is based in Cary. It's called Accident Research Specialists.
What's the name of it again?
Hang on, I'm going to go to the expert.
What's the difference between you and a versus Wake County Sheriff's Office, correct?
The effect of sound on.
Again, in at least one state, have you been qualified?
Sorry, guys.
Back off. Back off. Strike that. Were you hired by myself and Mr. Griffin to do some analysis on what occurred? Correct?
Yes.
And also the location of Maggie's body.
Hang on, I got to get the
Back off.
because the qualifications are relevant.
Trigonometry, those kinds of things. Is that correct?
Yes.
And you have been qualified multiple times on that issue
Yes.
as an expert to give an opinion.
Yes.
And again, going back to the other two, you've been qualified as an expert to give an opinion by many courts, several courts in shooting incident reconstruction, acoustics engineering, and in motor vehicle reconstruction. Is that correct?
Yes, it is.
Your Honor, I move that this witness be qualified as a expert in the three areas I just mentioned.
Mr. As a state, he's admitted without objection as an expert in the fields that he's offered.
So
Okay.
that right there, a lot of people overlooked that throughout the entire day of trial. And that I thought was the state's biggest mistake from today. I've talked about expert witnesses before in domestic relations cases and in other cases where you're having experts give opinions on psychiatric or psychological thoughts or psychological diagnoses. And the way that I have gone through how an expert is qualified, and it really comes down to the scope of the qualification. So once that witness is offered as an expert and then no objection is made, that witness is an expert adjudicated by the court to grant or to offer his expert opinion, which is essentially giving a narrative of how things occurred and why they occur that way. He is deemed an expert at that point in time, which is why the scope of the qualification is so important. I've talked about this in the context of psychological assessments. There is the difference between a treating psychologist or psychotherapist and a forensic psychotherapist. And if you are qualified as an expert in the psychological treatment as a treating therapist, that is the scope of your qualifications. A treating therapist that is qualified as an expert in psychotherapy, without that little caveat, forensic beforehand, is only allowed to opine as to the diagnosis, prognosis, and treatment of that patient. They are not allowed to offer an opinion as to what the cause of that patient's maladies are. That is that forensic part. If you want someone to give an opinion as to what caused the patient's psychological issues, you must qualify them as an expert in forensic, psychology, and psychiatric evaluations. You cannot just simply say they're a psychological expert and then have them go down a road that takes them down 9 million tangents where they're just giving expertise left, right, and center. You saw this in the defense when they were trying to cross-examine witnesses for the state and cross-examining them and saying, well, this isn't, you didn't reach this conclusion. Well, that was outside the scope of the examination or the qualifications. The defense tried to do it. Here, the prosecution makes the mistake where they allow the vague qualifications to come in. Physics, acoustics, and essentially some of these reconstruction issues. That I thought was a big misstep on their part, and it led to a lot of the fights that we saw down the road. But keep in mind, the judge, listen to the emphasis on the judge's voice.
Okay, so
Objection
Ready?
is admitted without objection as an
There you go. Sometimes inflection doesn't mean shit. Sometimes it means something. In this particular juncture, the state said that they were sitting there going, I thought when these qualifications were read through, there was going to be some voir dire. There was going to be a little back and forth. Emily, I see in the chat, I was so surprised they didn't object. I thought we were going to get voir dire. I thought we were going to get some analysis or some clarification on what this witness could testify to. We didn't. Another thing happens during the course of his examination and in cross-examination that I wanted to bring up with regard to Emily's comment here, because it's a thing that lawyers know. We have to disclose who their experts are, or who our experts are, when we're asked in discovery. We have to disclose who they are. If they have prepared a report, we are required to tender that report to the other side. We must give it to the other side. If that expert has given us an opinion and laid out the foundation for that opinion, we have to offer and provide that opinion and the factual basis for that opinion to the other side. But what a lot of attorneys will do is they will essentially and this is both sides, they will hide their experts or the scope of the qualification, or the scope of the opinion behind the absence of a report. And what they'll do is they'll kind of wait until the last second and they'll have the conversation with the expert. And I said, this happens on both sides. Absolutely happens on both sides. They'll wait until the last second and they'll say, here's the opinion offered, or the expert will not give the report or won't produce a report. You can't require the other side's expert to produce a report. I thought this was very fascinating trial gamesmanship, litigation practice. But I also thought that Poot's question really kind of hurt himself as well, because he didn't really get down and narrow down the scope of the expertise either. So this then becomes this massive open door that both parties are allowed to argue, which leads to some of the messiest direct and cross-examination I think you can see out of an expert, where people are giving opinions left, right, and center. So that was some of my initial impression, like while this was happening, I was going, why are we not objecting? Like, why are we not asking any questions? Why are we just allowing it without objection? I thought it was curious, to say the least. Now, I will say that his work, at least in some of the stuff, I thought was pretty fascinating. So let's see if we can get beyond the qualification to some of the trajectory. The image on the screen, I don't know that we'll be able to find the image again, but when I talk about it, I'm gonna make reference to this. This is an image of one of the rods that he used to determine trajectories of the shots. The defense or the prosecution makes the point in cross-examination, and it was a good point that they didn't focus on enough because they wanted to make all the points. Sorry, they wanted to make all the points. They didn't focus on this one enough. They said, could a bullet traveling through a soft object like this, could that alter how the trajectory would be perceived from someone doing an analysis via this method with a rod through the location where the bullet entered? And he points out to the protractor, or the angle gauge that's laying and resting on this rod that is sticking through a piece of cardboard. And I was going, well, that has weight. Why don't you ask that question? Because that could skew the angle of the rod. But the question wasn't really asked. Exceedingly frustrating, because that was just what today was. That's what this whole trial has been. Okay. We're gonna continue onward to essentially, there's some of the munitions that were found. Let's go to the location. Oh no. Let's see. Here's some of the report that he's preparing. So let's go through this.
I mean, from dentist offices, everything, but
We'll talk in just a minute about how you put this together, and the process I think is on here. Okay, how about let that one go? And this is without, you took the roof off of the shed, correct?
I did.
Okay, go ahead. We can see the doghouse. We can see the quail pen. We can see where Maggie's body was, and we can see where Paul's body was, correct?
Yes.
Okay. How about do that one more time? That would be Maggie's body near the doghouse,
Yes.
and that would be Paul's body over here, correct?
That's correct.
Okay, keep going.
Small side note. This software is awesome. This software is awesome. It uses essentially multi-directional lasers to determine the distance between objects that it hits, and it maps an entire space. Honestly, this is so new aged. It is amazing what they can recreate using this software. And you really have to wonder, in criminal prosecutions several years ago, whether this software and whether and how much this software would have impacted some of those trials. I just thought it was remarkable when you're watching this, and the state used it, the defense uses it. It's relatively new, but it's really pretty cool.
And why did you do this particular visual? Does that make it easier to see where everything is relative to each other?
Yes. In the scan, you can just cut the roof off. It just makes things easier to see.
Okay.
The roof was of no importance to me.
Right. Next. Now, tell me what this represents.
Well, this is where I start constructing some lines, and this is just an overall shot looking straight down. Like, this is a bird's eye view of the scan, and the dog kennels are in the bottom right, and the hangar, the barn, is kind of in the center top of the picture. And it's just, there's nothing really, of this particular shot. It just illustrates what you can do. And what I did, for instance, is I drew some white lines in there. Those are measurement bars. One's 25 feet long, one's 50 feet long. But the scan itself, you can measure very accurately anywhere in this, because this is not a picture. What it is are their points. And there's so many points. There's millions of points, and there's so many points when you put
Okay,
Next.
fast forwarding. We've gotten that part. Now we're going to get to some of his actual expertise and how he reconstructed this, because this becomes the crux of the argument that ends up happening today in court. So let's listen to this on direct. Honestly, I think Poot was the bad choice for the defense to do the direct examination on this witness. He doesn't seem to grasp the material as well. So when he's asking the questions on this, he's not getting the questions asked properly to get the right answers out of the expert. Experts are tough. The information you get out of the expert is only as good as the question being asked of that expert. And a lot of these questions didn't seem to have a lot of the knowledge he would have needed in order to ask the right question to get the right answer. That said, the attorney that the prosecution pulls up at the end, I have thoughts on him too. We'll get to that, but this is essentially the primary point. A lot of his analysis wasn't really focused on Paul. It was focused on Maggie and the shooter and the trajectory of the bullets that passed through and killed Maggie. So this is essentially the biggest point that the prosecution has to attack. They must attack this point. If they don't, this becomes a very difficult case for them to prove. So let's go ahead and look at this real quick and walk through how he testifies about what the trajectories told him about the shooter.
This is a thought process. Okay, what is this telling us? So that's what I did here.
And what degree line is that one on?
That's on the 1.5 degree.
Okay. Next. And what does this depict?
That's the exact same shooter, except that shooter has its barrel on the 3 degree line.
Okay. But he would be on the other side of Maggie's body and on the other side of the doghouse.
Correct.
Okay. Next. Okay. Now this has 2 individuals in it. What's the one behind?
So those are the 2. So the shooter,
Okay.
the shooter behind is the 1.5 degree. The shooter in front is the 3 degrees. So that kind of gives the range of this person being able to make that shot. And so to me, because of several different factors, it's much more likely that the angle into the quail pen was flatter than 3 degrees, which we talked about before. One of the main reasons is there's no shell casings over behind the doghouse.
So this person up front, what did you just say about shell casings?
There's no shell casings anywhere close to that person.
And I guess, can you demonstrate for us how you're depicting this person's holding a gun? I mean, are they, you say from the hip.
Yes.
What does that mean? How about demonstrate, if that's okay, Your Honor?
So what I would say is that what I did for this purpose is, instead of having it here, I put it down here, about as low as I could go.
Okay.
And within like a shooting stance, like a shooting position. You're not aiming, but at least you're not aiming in the traditional sense, but
If you're aiming, it'd be on your shoulder, right?
right. So I stretched that gun down until I could just still keep my hand like I was shooting a gun.
Now, from the shoulder, where generally would they be? You've got, to have that downward shot.
It's really hard to put a shoulder shot on that trajectory just because it's so low.
No, it's not. No, it's not. And this was a point where I didn't think that the defense did this right, and it led to a prosecution question I thought was great. People in the chat aren't silly. I think you guys can reach the conclusion of how someone could hold a firearm against their shoulder and the firearm still be at that height. It's simple. You drop the rest of the body. Now that asks a question that the prosecution then has to work around. Multiple shots were taken at that trajectory from different locations. And in order for the shooter to be down on their knee or crouching and to take 7 shots, which we are assuming, given all the other facts that are in evidence, were taken in somewhat rapid succession, that shooter would have had to either scoot along the ground, dragging their knee between shots, which would have made a mess of the place and also would have been rather odd, or they would have had to return to a kneeling position in between each shot. So you're either kneeling and scooting your knee, Or you're kneeling, getting up, moving 2 feet, kneeling again, shooting, getting up, moving 2 feet, kneeling, shooting again. It's the motion. Now, Dick, I think, could have made a better point about this, and it suggested to the witness, which would have taken the ammunition out of the prosecution. If Poot had asked the witness directly, well, what about if they were kneeling? That witness could have very easily explained, why would you get down on your knee, get up, move a lot, get down on your knee again, or scoot your knee and drag your knee around? It's not a logical way for a person to maneuver when they're firing in rapid succession. So it's just an interesting theory. It's an interesting thought. And then the prosecutor, we'll get to that in a second. The prosecutor goes through a lot of these hypotheses. What if, or maybe, or perhaps. The problem with the maybe or perhaps is that doesn't work for the prosecution. The prosecution cannot rely on maybes or perhaps. And this is actually a really good point for me to bring in, because I know that there's been a lot of heat and people making comments about how any of the attorneys are analyzing this or looking at this, and how they're not really being even-handed in their remarks about the prosecution or the defense. It's true. They both have different burdens. The prosecution has the burden to prove to the jury beyond any reasonable doubt that this is what occurred on that night, that these are how the shots were taken, that this is who the shooter was. All of those things have to be proven beyond any reasonable doubt. The defense has the burden to instill doubt and to make sure that doubt is reasonable. If the prosecution is resting their case on, it may have happened this way, that is not beyond a reasonable doubt. They have different burdens, which is why when we're criticizing direct and cross-examination of both teams, we're criticizing them in view of their differing burdens in the case. And that's just reality. Like I said, I think Poot was the bad choice for this direct examination. I would have asked those questions about the kneeling, because you know what it did? It gave the prosecution the opportunity. I don't think they seized on it. The opportunity to do what they just did. I mean, at the end, they hold up a tape measure and they goes down and kneels. I'll get to that. I just didn't think that this was as effective as it could have been in the hands of another attorney. So, yeah. Joe Tracy, unreasonable doubt made with wild speculation is not reasonable. That's true. But is anything that he is telling you, is any of that wild speculation? Because I can tell you right now, the trajectory stuff that he was testifying to is fine. That's fine. There's logic and there's science and certifications, there's all those things, but your brain has to also kind of be in the mix here. And I'll explain that a little bit further as we go on.
Because even a small person going like this, 4'2", even if you put the barrel on the quail, then it'd be above the hole. So it just doesn't make any sense.
Okay, next slide, please. And so this is without the guy up front, because you concluded this is where the person would have been.
Yes, for a person of this height, this is to me because of its proximity or closeness to the empty shell casings.
Okay, next. Now let's look at the doghouse
All right.
trajectory shot.
We're going to fast forward because we're
I
going
can
to
do
do
this, so I'm
something.
not pointing at somebody.
Hang on. All right. So the moment of court that everyone has been talking about, the moment of court that essentially, yeah. We'll watch it, and then I'll give you kind of my impression of what takes place. So we've got Dick Harpootlian holding the 300 blackout that's in evidence. Mr. Sutton is trying to position Mr. Harpootlian in a position where this shot could have occurred from a standing shooter.
So I'm not 5'2". or 5'4". I think you should 5'3" or 5'4". But
Can we start with how this is beginning? Like, I'm not even that remark. Look where he's facing. Look where he's aiming the rifle right now. You couldn't have stood to the side or some other angle aiming at that door where you could have actually explained this without pointing the barrel end, the naughty end of a rifle, long pistol, out at the gallery. Just thoughts.
position me tempting, but I don't know how I can.
Okay. Let's watch it again because other people have said that someone from the prosecution team does something. I actually want to take a look at this again. I'm going to slow this down a second. You guys all heard him say tempt me. I'm going to slow it down a second so that we can see what the prosecution is doing. So you heard the words. Let me rewind it a bit and we'll get there again.
Do this.
Right there. So someone was very correct in pointing that out. I didn't catch that in live time. Now I have remarks for everyone. All right, so now we can talk about the blame. Is this appropriate? And for those of you asking, I cannot see. In the bottom of the three screens depicted, there's the prosecution table. Immediately behind the prosecution table is the gentleman with the yellow tie and the blue sport coat. On this screen to his right, you will see a gentleman that looks to be a little bit older with gray hair sitting behind Mr. Murdaugh. His hands are raised up, essentially providing a target for Poot to point a weapon at. Ultimately, this is still my conclusion. Still not appropriate. Look, in any other context, if this was let's say this was a toy gun, let's say it was a wooden gun, let's say it was something that was simply a demonstrative and not an actual firearm in a murder trial. Maybe. I still don't think I like the joke, but maybe. But the thing is, this is the firearm, and if you think about what he's trying to portray here, what he's trying to portray is the angle that this firearm was at when it took kill shots of Maggie, who's the victim in the trial. I didn't particularly care for that. And I didn't particularly care for the tempting remark. In any other setting, if you're not handling a firearm, you can make certain jokes or jabs. But this one, I would not have really appreciated. And I'm kind of surprised that the judge did not, when we took a recess or took a minute, didn't essentially admonish both sides, saying we've played fast and loose with the firearms in this courtroom. We're not going to do it anymore. It's not my courtroom. I'm not the judge. I'm not either of these attorneys. I don't think this played very well for me. Now the gallery laughs. Okay, that's fine. That's okay. I am not comfortable with that in a courtroom that I am in. That's all I'm saying. You guys can reach whatever conclusions you would like about the joke and whether it landed or didn't land. I'm not going to make any remarks about that. I will just say that in a courtroom, I have seen far too many of these firearms being handled pretty carelessly. And to the point that others are making, well, it's a courtroom, it's safe, it's all of these things. The issue I have with that is that, Mr. Baldwin, Alec Baldwin, was handed a firearm that he thought was safe. It wasn't. You treat guns with disrespect, you get pretty bad results. That's all I'm going to say about it. I didn't care for it. And I don't really care for the prosecutor, whomever is on that prosecution side, pointing a target and kind of tempting the joke to be made. So that is my thought. I've been around firearms for too long and in too many occasions to know that the firearm is never safe. It should never really be treated as safe as far as in the hands of everybody else. Yes, I've been around firearms in the South. I've been around firearms everywhere. I have shot any number of firearms of any make, model, caliber, style. I don't care. The second you start disrespecting that firearm is when bad things start happening. So that's kind of my remark. So that was the joke that Guts made. And then we start to go to the different trajectories here, talking about the shot that leaves out of the back window. So the jurors own all the firearms. They do. If they do, then what this witness is saying is going to reign true to a lot of the jurors, because there was a lot that this witness said that a lot of people were critical of that I thought was kind of unfair.
And so when I was there, there's like a stand of pine trees that have been planted behind the kennels.
Right.
And so what I did, there are 9 pellets, but the pellets had already spread out by the time they went through the window. In fact, there was 1 pellet still wedged in the windowsill itself.
That you found?
That I found. But there was a tree and it had some ivy on it, but it had damage. And so what I did was I located that damaged tree and put a mark on it. Just put some yellow tape there. I went back in the feed room. If you look at the pictures of the feed room, there are some bloody footprints from tennis shoes. And it's just as I believe it was Chief Deputy Kinsey talked about, Paul being about midway in the room. That's the approximate location. So I stood there, but I knew Paul got shot in the chest. So I lowered my head about eye to chest level, and I looked through each hole until I saw the tape on the tree, which is where the sap was coming out, where the pellet.
I'm pausing here because there were a lot of remarks, both with the acoustic analysis and with the firearm analysis. Do I know what type of trees those are? In South Carolina and low country, those are very likely loblolly pine. They grow pretty quickly. Why do I know that? I was a natural resources major at the great North Carolina State University in their forestry department. So we're going to answer some questions about the trees. Loblolly pine grows in sandy soil out in South Carolina and in North Carolina. It's actually used to harvest for a lot of pulp mills. We're going to go back to this particular picture, loblolly pine, and how trees grow. People were saying, well, wouldn't where the shot entered, wouldn't that be higher the next year? That's not how trees grow. Trees grow out. So the cells actually grow from the inside out. So the tree is pushing the trunk outward, but it doesn't really push the trunk up. That's not what happens. Trees grow high from the center. They grow high up at the very top. That's where they grow their height. This is actually, you don't even have to take my word for it. You ever see people go carve their names in trees or hammer a nail in a tree, and you go back several years later, 20 years, 15 years later, and that name that was carved, that's no higher than it was when you carved that name in the wood. The nail that you drove into that tree is no higher than where you drove in the wood. Then the other remark on the acoustics that people were making comments about, loblolly pines. You know why they're called loblolly pines? Because they grow, and the only growth that tree has is at the very, very, very top. That's the only place where the fronds are, where the pine needles are. Everything else is just tree trunks. That's it. So if those trees are continuing to grow, they are not growing noticeably larger out in the width at all. So the acoustics, to the extent that these trees are here and the trees are being argued as altering the acoustics, that's not changing the acoustics, because there are no tree branches in loblolly pine that low. So yeah. So people have asked me the question, what should I go to do college, or college and then law school, or do you ever use what you have in law? Do we learn in college in law school? Sometimes. And sometimes it comes pretty handy. Like when you're trying to explain that a bullet that was fired at a tree is going to leave a mark, and that mark is not going to go higher as that tree grows. And that when you're trying to measure acoustics from a location and all you have is a stand of loblolly pines between where that shot is fired and the tree where it and the house where it was heard, and loblolly pines are the only thing in between, That's not going to change from year to year. Kind of funny. That was my little side note. Thank you for indulging me. That's fun.
That is the shot line or the trajectory of the pellets in the shotgun. And that's where the damage to the tree is. It's leaking sap.
Okay.
And
what is this?
that was the hole in the window that if I stood roughly where Paul was shot in the chest, it was the only hole that lined up with that tree.
Okay,
and then-
what is this?
And that shows basically at the door sill, the threshold of the door to the feed room, the height of the shot, which was at the door sill, it's 3'11".
Okay. Was it on an upward trajectory?
Upward trajectory.
Okay. Next.
And so what I did there is just to demonstrate it, obviously because there's a string there, can't put the barrel right on the string line like we did in the computer with the green lines. I just held it beside it. I'm 5'10". I have normal shoes on here. That's the stance that I would have to take to shoot up that string. So it's,
And at what height would that hit Paul in the chest on that trajectory?
that's like about right at my hip or so. Yeah, maybe just a little bit lower than my hip if you looked at the butt of the gun. And I'm 5'10".
You're how tall?
5'10".
So it's somebody not 5'2" to 5'4", but somebody slightly taller.
Right, or moving the gun up and down again, there's a variable here, of course. And then what I did was demonstrate, because there have been some, talk, well, that's me standing, again, I'm fairly comparable in height to Paul Murdaugh. And what I did was I just let the string touch where the wound is in his chest, the entry wound. And if you look where my feet are, you'll see I'm just beyond the door, which is right where the bloody footprints are. So another way of confirming that this all makes sense here.
And those are the bloody footprints.
Those are the bloody.
All right, we're going to fast forward across examination because if we don't, we're going to be in trouble. Here's the thing. A lot of people were critical of this particular witness. Let me pull this down while I do this. Saying, well, a lot of this isn't scientific science, or this isn't this isn't that. I want you guys to remember that's not the defense's job. They don't have to prove how something did or didn't happen. They don't. They essentially postulate as to a reasonable alternative to that which was given to you by the prosecution. Reasonable alternative does not mean that you have to prove something occurred the way it did. Common sense. Common sense is sometimes is easier to comprehend to a juror than an expert who has all the credentials giving them information. With regard to the shotgun, I'm going to agree with you. With regard to the shotgun, I don't think they proved anything. I didn't learn anything new from the shotgun. I thought, if anything, the shotgun kind of corroborated the crime scene investigation report, that was the angle and trajectory of the shot that was fired. The only thing that the shotgun was brought in was that he found evidence that they didn't, namely the scar on that tree and the other the other shot pellet that was recovered. That part didn't change it. It was Maggie's. It was the words, Rob. It was the evidence on Maggie's shots that they needed in. So that was what I thought was interesting. But when people are making comments about his expertise and what he was there to prove and how he didn't prove how something occurred exactly how it was, it's not his job. His job is to allow the jurors to reach a reasonable alternative to that which was given to them by the state. And it has to, and what he's giving you in as far as this information is what takes that doubt and makes it doubt, turns it into reasonable. So that was kind of one of my comments here. Now let's get to the cross-examination, because I thought, and I know people are going to disagree with me. I don't mind if you guys disagree with me, honestly. This trial has been backwards, upside down, left, right, any which way. Finding up from down at this point is impossible. I'm just trying to help people view the evidence in a way that maybe makes more sense than how these attorneys are laying it out in court. I don't know. So Mr. Harpootlian, we've made his remarks. Now we're going to cross-examination, and we get to the witness, or get to this this prosecutor who can get a little bit spicy. So we'll go through some of the spicy cross. Yeah. I'm not even showing you the video because I'm an idiot.
Retained by them. When were you retained?
Jim Griffin called me, I want to say it was about the middle of September of 2022.
And I know we've seen your PowerPoint. Did you, is that your report, or did you prepare a separate report for defense?
The written report that I did in this case was on the acoustics testing, but the PowerPoint was just trying to pull, it's a big file, of course, but just trying to pull it all into one place.
Did you provide any additional reports to defense, or was the PowerPoint the only one?
Just the PowerPoint, and then I had maybe a 4 to 5 page report on the results of the acoustics testing.
And when did you finalize your PowerPoint that we just saw?
Now you see the point.
In its final form, that would have been yesterday.
So you finalized your PowerPoint one day before your trial?
Yes.
Is that standard for you to do?
Yes.
All right. And what's your how much are you getting paid for your services?
So the company charges $3.50 an hour for my time.
And how many hours have you worked on this case?
Oh, Lord. A lot. I couldn't give you an idea, but I made 2 trips down here. I've been to Moselle twice. I read through a bunch of documents, studied pictures forever. Got ready for trial. Of course, that took a while. I would probably say that I have, somewhere between 40, 50 hours in this case.
40 to 50? Is that your estimate?
I would think so.
And travel incurs additional expenses. Is that why you kind of mentioned it separately?
It does, yes. So, the company charges anytime I'm traveling or working.
Have you ever done any work for the law firm formerly known as PMPED?
No. Because I've been doing this for so long, and I do a lot of railroad cases, I have been on the other side of that law firm, and I've been deposed, like on the other side. They took my deposition. I was on the other side working for a defendant. But I've never worked for them directly, like on say a personal injury case or a wreck case.
Have you ever been retained to work on the boat case?
Yes, I did.
Okay. Tell me about that. What was your retention for the boat case? And by the boat case, which one are you referring? Which one? What do you understand that to be?
Well, the boat case, the Maori Beach case, so the one that occurred down at Paris Island. So I do boat accidents. I do small vessel, watercraft, jet skis. I've actually worked on ship accidents, ship collisions before. So I do a lot of maritime and boat accident work. And I was called by Jim Griffin a few years ago. It would have been probably, within a few months of that accident. And I did an investigation of the boat crash.
Do your services also include a retainer? Like, is there some sort of retainer to work off of before the hourly billing kicks in?
No, our company is pretty simple. We just bill by the hour. So we don't do contracts or retain.
On firearms or pathology?
Chat is funny. Y'all, which way do you want it? Do you want them to be paid a ton of money, or to not be paid at all and be incompetent? Do you want them to have no conflicts, or do you want them to have some conflicts? At the end of the day, a lot of these questions are nothing. They they don't really do one thing or the other. But a lot of people are very, very opinionated about a lot of this stuff right now. And I'm struggling to find why. That's the struggle I'm having. I'm struggling to find why. Why are we so upset about this particular witness?
Procedure, there could be lots of variables that don't matter. But if the variable matters, then of course, that would affect your opinion.
And in engineering, and we're thinking of, I think you said you're a mechanical engineer
Yes.
by trade, by education.
Yes.
My dad was.
So do mechanical engineers engage in speculation?
Not in the context of giving opinions.
Okay. And do mechanical engineers, when whatever they're engineering or whatever they're opining about, do they base their opinion on assumptions?
Yes, they do.
Not primarily, not even really. Your opinions can't be based on assumptions. Now, there can be aspects of your analysis that you have to test, but whether it's an assumption or a guess, that does not make for a good engineering opinion.
Appreciate that. Thank you. Are you a member of have you had any formal training in pathology?
No.
Have you had any formal training in firearms, how they work?
No.
Are you a member of any organizations that do that line of work, that do tests on firearms or pathology?
No.
Have you taken any shooting incident reconstruction classes?
No.
Do you have any sort of...
What does, and this is kind of a question for the chat. I saw people having all kinds of opinions on this. What do any of these qualifications matter to what he testified to, which is essentially trajectories, lines, and where they go and the direction they go, angles? Why does he have to be an expert in accident reconstruction? He just reconstructed something. It's not his job. His job is not to do this. His qualifications was that of an expert in physics, in acoustics, in engineering. He wasn't offered for these things. This part was fascinating to me because that's not what he was offered to present. He was offered to present angles and analysis of angles, and he used a lot of the state's own evidence in preparing that computation or in that analysis. It was fascinating that this was the road they decided to go. And to be quite honest, I come from a family of engineers. Try to convince an engineer of something that doesn't line up with the math that they see or the math that's there. Try to convince an engineer of that. Good luck. So you don't need a lot of this expertise to do these things. Well, here's what he's testifying to. Shooting reconstruction. He's testifying to bullet holes that were acknowledged and identified by SLED as being consistent with this injury. He's testifying to casing that was acknowledged by SLED, located by SLED as being the cause of these injuries or of these murders. He's testifying using the information gleaned and gathered by SLED that he goes and verifies on site. Angles. At some point in time, common sense.
Verifications in shooting incident and reconstruction?
No.
Have you taken any classes in gunshot wounds?
No.
Have you ever done any studies on bullet trajectory from out of the muzzle of a gun?
Yes.
Okay. What studies have you done?
I've done all kinds of testing.
All right. Such as?
For instance, one time I had a case, it was a murder case where a person was shot through a car door. and was shot with a .357 Magnum, and the door had maybe 6 bullet holes, and each of the bullet holes had different characteristics. So I went to the junkyard.
Watch the posture of the attorney that's asking the question. I have seen any number of attorneys act this way. Hell, I've probably been one in one of these trials or not. The flipping back and forth on their notepad and the constant movement. This guy he's frustrated with the questions and the answers he's given. Like this is a rather frustrated attorney, and he's having trouble controlling his own emotions. Just watch him. It's interesting.
And got 25 to 30 of these doors. And I spent a couple of weeks shooting that door with a .357 Magnum at different angles, different distances, until I could replicate the bullet holes in the actual, in the door. So what you're doing there is that you have a door as evidence, and then you're trying to figure out, okay, what does that tell you? Not the same as what I talked about today, but similar. I had a case one time where there were 2 deer hunters in the woods and one got shot at long range. So we did a lot of long range ballistic testing of the ammunition in the firearm to determine the drop distance of the bullet and to understand where the one hunter would have to aim the weapon. I have done proximity testing with firearms by looking at the stippling. So in other words, I have a rig that I can put a pistol in, and then I put target. A lot of times I use sheetrock. And then what I do is I fire the gun at increments back and look at the pattern of the stippling. Sometimes you'll get soot and stippling, and sometimes that. So it would all be testing within the context of the cases. You know, when I get involved in a firearms case, those are the types of things types of tests that I would do. It's just a general part of our business. When we get presented with an engineering problem, we do testing.
And those testing, any of those studies that you did, were they subject to peer review or published in any publication?
No, I typically don't write papers or submit papers. I do the work.
So it's you doing a test on your own?
Yes.
Is that right? That's what it is?
Yes, or with, of course, people in my office help.
With your office?
Yes.
Okay. And are you a member of the International Association for Identifications?
No.
Firearms identifications?
No.
You have any certifications along those lines whatsoever?
No, I'm not a firearms expert or a pathologist or a wound expert. That's not my area of physics. It's not my area of expertise.
Okay. So is it fair to say then any opinion you rendered on relating to firearms, we shouldn't rely on it then?
That's not what I said.
Okay.
If it's related to exterior ballistics and terminal ballistics, then yeah, you can certainly rely upon it. But I'm not going to.
All right. About this point, this is prosecutor starts losing me. I was trying to hold with him the entire time. He asked if he's certified in these things 9 million times throughout the entire cross-examination. Honestly, it should have been objected to. I don't know why it wasn't. Then he starts interjecting with commentary in the middle of the answers. That should have been objected to. All of these things should have been objected to. This is not what this expert was brought in to testify to. He's not brought in to testify to essentially what a firearm does when it's shot through a person, or how crime scene reconstruction works. This guy is testifying to angles. This is quite literally engineering. This is what he does. Like, yes, engineers, they testify to the speed of something going at a certain direction or distance, what it's going to hit and how it's going to hit it, and how to backtrace that to where its origin was. Like, all of these different remarks were just really frustrating. And I wonder if there's a juror who might have thought that as well. I know a lot of people have opinions that the expert sounded like the person who didn't know what they were doing. I reached a contrary opinion just based on how I know these cross-examinations should go. I just didn't see what was going on. All the questions. What's the point we're making? What's the point we're making? And I know that I'm going to get a little bit more frustrated because this attorney doesn't stop. Trajectory is angles. That's math. That's It's what engineers do. That's why I'm not an engineer. I stopped seeing the math. I started doing engineering. So if it's shot into a door, it deflects. Yes, it does. But a lot of the points he's measuring is from the point of deflection to the point the shot goes. And there's a lot that's going on here. Again, I don't think any of the Paul stuff was contrary to what the crime scene investigator did for the prosecution. I don't think it did anything. With regard to Maggie, he's using the prosecution's evidence, and he's just mathing the evidence that was already introduced.
To testify about wounds or pathology or anything like that, and I haven't.
All right, I want to start with the cell phone. I think we ended on the last slide, the charts. I don't know where those are. Yeah. I'm showing you Defense Exhibit 141 and 142. I believe you testified. Can I have the PowerPoint? Sorry.
Longbird's
I believe you
trust me, this
testified
point
that you
earlier.
created these graphs. Is that right?
No, I didn't. This is an Excel graph from the data. So it's just the raw data that was presented to me.
All right. Well, who created it then?
I'm not sure. I just reviewed it. I'm not sure who did this.
All right. Well, can you tell me? I think you testified before that. Well, show me the time, if you would, and permission for the witness to come down. Show me the time that you indicated the phone was thrown from the car, if you wouldn't mind.
Well, I got it specifically on my laptop. I can show you in general. It's up to you. I mean,
Well, this is an evidence, so I'm asking for you to come down and identify on here where it is.
you want to know where the car passed, where the phone was?
Just for clarification, yeah, 1 second, sorry. Just for clarification, we're looking at this chart. What is this showing us?
That is a graph of the speed of the Suburban versus time. So speed is on the y-axis, or this is speed, and then that's time. So time's going that way. And as car speeds up, the line gets taller.
Okay. And it says total time 16 minutes. What does that refer to?
That's the time it took to drive from Moselle to the parents' house.
Okay, and the sled, and then it says next to that sled test drive during day. What does that indicate?
What that is it's just comparing. It took 16 minutes, Mr. Murdaugh, and then Sled did the same drive, not at nighttime, but during the day, and took 17.58 minutes.
Okay. All right. So as I was saying before, I think you testified. You said you indicated a point where the cell phone had been thrown from the vehicle, or at least the time correlation. Could you please identify where that is for us?
No, that's not what I said.
All right, well, what did you say then?
I said that when the car passes the location.
Okay.
Right. I
Sorry.
don't have any information about.
When the car passes the location, where is it indicated?
I think it's that line right there.
Okay. And you say you think. Why is it that you think?
Well, it's not labeled, but it's on my laptop. I'd be glad to get my laptop.
Well, this is an evidence, and this is
2 points, and both factions of the chat are going to hate me for this. 2 points. One, why is this in evidence? This is in evidence because there was no objection made by the state when it was offered into evidence. For example, objection, Your Honor, the bottom of that graph does not depict the times that are being testified to. This should not be admitted as an exhibit. That would have been a lovely objection to make, and it probably would have been sustained. And the defense would have been there, and they probably would have said, now I got to print a new graph with the times that are depicted on the bottom. Odd, very strange. Second, it doesn't matter because the jurors are going to remember what he was pointing at in part of that graph. What's more relevant, the graph itself or the testimony that went along with it? What came first, the chicken or the egg? I don't know. It's one of those things where this lawyer lets in the graph. that is a flawed graph. It should not have come in. I don't think it should have. I think it was kind of junk. He lets in the graph. Okay. He not only lets in the graph, he lets this witness testify to all of these things. And then during cross-examination, the attorney's trying to make a point about the fact that he let a graph in that he shouldn't have let in. And that he can't point to the exact time because the time's not showing. What is happening in this trial? Both of them are to blame here. I don't know which one of them I put more blame on, honestly. And then they get into a certain thing, a measuring contest over the laptop.
What the jury's going to consider. So I prefer to work on this.
Objection. He has indicated he has a specific date on his laptop. If he wants the real answer, he'll be happy to walk to his laptop and get it for
Oh, I
him.
paused at the
He
right
says
time.
he's
Now
looked
you
at
have the
this.
trifecta.
That's what it is.
Speaking objection.
I mean, he's asked the question 3 times. He's answered 3 times.
Cross-examination, you may proceed.
You're not able to find it on here, are you? Looking at this chart.
Well, it's either this line right there, or I think it's this one or this one.
All right, does engineering engage in I thinks and maybes?
Let me get my laptop.
Well, I'm just asking you, can you identify it on this chart?
Well, I mean, this is a really big file. Well, I will answer it, but I don't have the whole file memorized, so let me just look at it for you. That way you'll know the answer.
This is great.
Can you point it out on this chart without
No control of this
without
courtroom.
reviewing whatever you're about to review on your laptop?
No.
Okay. Can you identify 912 on this chart without reviewing anything you're about to review on your laptop?
Well, I mean, you want me to answer the first
This
question?
is fantastic.
You answered it. You said no. Can you
are we doing?
identify where on 912 on this chart is?
No, they're not.
Okay.
It doesn't have any numbers written down.
Thank you. Can you identify where 920 is on this chart?
Well, hold on. You want me to answer your questions? You want me to answer the first question?
The questions, please. Can you identify where 9?
Who's winning the pickle measuring contest in this moment? No? Have we figured this out yet? It's a bad graph. He's got the computer. He can tell you the exact time if you want it. I don't want you to tell me the exact time off your computer. I want to make my point, dang it. I'm going to make my point, dang it. The point is the graph doesn't have the numbers. This entire thing is a charade. And it's egged on by the attorney who's just asking questions constantly, the witness who's clearly getting defensive, Poot, who made a speaking objection that probably shouldn't have been a speaking objection, and the court who hasn't interjected yet to say this is a joke. Why are we doing this? You're right. Who is this? Where is this? The computer graph isn't in evidence. You're right. The computer graph isn't. But what is the graph that's there and his testimony that went with it. And the jury's recollection of what he testified to and what line it was he pointed at. That's everyone's fault. Blame them all. Blame them all. This is a mess. If this is your cross-examination, this is the mess. You have lost control of the witness. You've to the point where the witness potentially is embarrassing you. And I'm not saying that he is, potentially embarrassing you by bringing his laptop, offering to give you the answer to your question with his laptop, and you're not letting him access the laptop to give you the answer to the question that you've asked. You started with a great point. You started with a great point that the graph wasn't great. And then you kept on going. And that was the theme of this cross-examination. You started with a great point and you kept on going. Yep, they are, Joe J, but they're allowed to when they're asked if they would like to. And they're allowed to ask permission to look at it, which is what he essentially does. The prosecutor in this case just says, no, I'm not going to give you permission to do that. Oh, this entire cross becomes a mess. And then I want to start getting to the point where he starts making like actual points, and then he disparages every person that's under 5'5". Where are we? Make sure I'm getting caught up here. More mathing. Sorry, Low Ducky. I didn't know that. Either way, it's in evidence as it is.
All right, reverse it. We'll start there. Go back if you wouldn't mind, a couple. Yeah, right here. Did you take this picture?
No.
How many inches does that look like he is tall?
Well, you can't tell how tall he is because of the way this picture's
Well,
taken.
what does it look like?
This shows his shoulder 64 inches.
What about his head?
You can't tell.
You can't see a number at the top of there?
No.
Bad question. This is why I don't. This is a bad question. No, because you're looking upward. I can't see the number for his height. It's a bad question, and this is one of several that he does. The measurement here is of his shoulder.
No, because you'd have to be above the top of his head or right in line with the top of his head. The only thing you can glean from this picture is that his shoulder is 64 inches above the floor.
All right, I'm going to ask you about use of Faro. Are you the one who actually operates the Faro equipment?
I do, but in this particular time, somebody else did.
And did your equipment, has it been calibrated recently?
Yes, we calibrate every year.
Every what? Sorry.
Every year.
Did you actually operate it this night?
He already
No, I
answered
believe
that.
Michael
Or this
Whitley,
day, whatever it is.
who's a biomedical engineer in my office, I believe he was the one that day that was doing the scanning.
You described Faro as the as a sort of a time of flight laser. Is that your testimony?
Yes, it uses a laser and it creates points. It creates a point cloud.
Is it fair to say that it's not actually a time of flight laser? It's a phase-based laser. Would that be more accurate?
I have no idea.
So you don't know?
I don't know.
All right, beginning at just the very beginning of the slide works. No, the first slide, just the beginning of the presentation, the defense exhibit. Yeah, like slide 1. Did you do the addition? I know that we're going to get to it, but there's some individuals you put in the Faro report. Were you the one who actually added that 3D render, or was someone else do it?
No, I had several engineers help me on this project. So Aaron Kiefer is an engineer in my office. He did a lot of the work on the point cloud. And Matt Kiefer, actually his brother, did work with taking those scanned people and turning them into shooters. So I would say 5 or 6 engineers in my office have worked on this particular project.
All right. What we're seeing here is a quail, what's called the quail pen. Is that your understanding?
Yes.
And again, this is not your picture. This was the one taken from the night of the incident.
This is a crime scene picture the night of the murders.
And next exhibit, please, exhibit 63. Would this be a close-up of that?
Yes.
And the panel here, that's a paper product. I think you already testified to it, but that's a paper type product.
Yes.
You can actually see it's like bending, warped because it got wet.
All right, we got to
Yes.
make it a little bit further. Let me see if I can get forward.
So it's pretty thin.
Yes.
All right, and the next, the body that's laying there covered in a sheet that was added after the fact. That's not part of the Faro scan. Is that right?
That is correct. That was added as well as the evidence markers.
All right. And I know the markers we see on this picture is just representative. Those are the placards. And is this the one where you tried to merge kind of what the placards were with the Ferroscan?
Yes,
And the little circular X's, is that the computer assisted drawing that you made based on the measurements performed by Special Agent Worley?
that's correct.
All right, if you would mind scoot forward to where we start with these green lines. There you go. All right, we're looking at exhibit, it doesn't even say, but exhibit with the 2 lines.
The remarks just at this point are just endless. And I cannot imagine that the jury has not noticed them or the judge hasn't noticed them. It's just one of those things. Really, that's where we are here. We're just going to make a remark after everything. I do want to make a quick comment. And I always forget to do this. If you guys are here for the first time, if you do like the channel, please subscribe. If you are here watching, do me a quick favor and hit the like button. I always forget to ask people to do it. Please do so. It does help drive people to the stream. I am going to be redirecting you guys to Peter as soon as I finish up here. I've only got about 5 to 10 more minutes of comments left. And then I'll get you over to Peter so you can watch his breakdown and analysis, Peter being lawyer, you know. But while I have this paused, please hit the like button. And if you like the content, please subscribe. It does mean the world to me. And these recaps have been fun, but pretty stressful.
Spread out, is that the representative of the 2 different angles that were noted on the quail pen?
Yes.
So do you know which one's which one's the 1 degree and which one's the 3?
Well, the 3 degree is going to slope towards the ground quicker. So that would be the bottom line. And then the 1.5 slopes less, it's more gradual slope. So it would be the top line.
Going forward 1. And here's where you inserted a 3D person as a 5'2" person. Is that who you inserted there?
Yes.
Okay. And you chose to insert a 5'2" individual shooting from the hip in that manner that aligns with that green line. Is that what you did?
Yes.
And nowhere on here is any other individual on that green line. Is that correct? You didn't put any other images here. You only chose to put a 5'2" individual slinging a gun on his hip.
Well, that's what matches. If the person was any taller, then they would have to be towards the quail pen. If they were any shorter, then they would be behind the shooter. Or the shooter would be in a different posture.
And do you have any idea if a bullet can ricochet?
Of course.
They can, right?
Yes.
If they hit something.
Yes.
And you don't know, because we didn't recover that bullet, but you don't know if that was a ricochet. Is it possible?
It could be possible, but I don't see any evidence from the crime scene investigation that it was a ricochet.
And none of the state's witnesses.
Okay, but it's possible, right?
I think it's very unlikely because of the hole in the side of the quail pen. Usually when a bullet ricochets, it'll get upset. So the hole in the quail pen should have been bigger.
So the shooter, according to your lines here, the shooter could have been anywhere on that line. Is that correct? Anywhere on that line.
Yes.
All right, if we keep going. This is just another one showing them same posture, just on different points of those lines. Is that accurate?
Yes.
So as long as that's done, and we'll not worry about the 5'2", 11-year-old, but if anyone's on the
I demand justice for any person that's beneath or below 5'5". You guys heard that right. Let's ignore the 5'2", 11-year-old. Are you kidding? Like, does he think that someone who is 5'2" has to be 11 years of age, or that no one that's 5'2" could have shouldered a 300 blackout? You know how many people I know that are 5'2"? They could very easily shoulder that firearm and maneuver that way and make those shots. This is that right there. Are you kidding me? 5'2", 11-year-old that you chose to put on that line. Right there. I mean, that's that part with this prosecutor. I was kind of done. I was going, the points that you're making out of this, I know that you're trying to get the slam dunk, but it's not doing it for me anymore. Like it is so clear that you are trying to get an answer that you're not going to get. And you keep flipping through your pages nonstop. It's driving me crazy. There's a lot of things that Poot does that drives me crazy. A lot of things that Creighton does drives me crazy. This cross-examination drove me nuts. Now he's going to go to the point of asking questions about, doesn't matter where the firearm is on that line. It doesn't. It doesn't, because that was based on a rod that had an angle to it. He took the angle and extrapolated that angle out just all the way down a linear line, which means that the projectile, when it was emitted from the firearm, because projectiles, you know, when they come out of the barrel of a gun, they don't just go, they go straight. You continue that straight line down the barrel, and that gives you exactly the angle that firearm is at. So it doesn't matter if the gun is doing, it doesn't matter if someone's jumping or sprinting or doing all this other stuff. The gun is at this angle. Doing all that other stuff would maneuver the angle this way and you wouldn't get the same line. It did not make sense. It didn't pass the logic common sense test. And I don't think that Redirect did a good job of clearing it up. Because here I am sitting here like I have to explain it or feel like I have to explain it because it was just poorly explained. All of it was horrible. So we're going to get to the last part, and then I'm going to read through super chats and get you guys over to Peter. The last part that we have is going to 8:53:30. 8:53. We'll go to 8:52:42. We'll pick it up here. And we're going to go. It just, oh. The 11-year-old, 12-year-old person of short stature. Why are we going to do this? So now we've gone after Bubba. We've gone after the rooster. We've gone after the horse that's in the middle of the courtroom that we're beating to death. Now we're going after anyone under 5'5". Sure. So the judge makes an interesting remark here, and I have to kind of give my opinion on this one because it's kind of not fair.
Didn't find any.
No.
So you're basically just saying this is the line. Based on the SWED, Agent Worley putting a dowel through and then figuring out the angle, correct?
Yes.
The two people you put here are based on the angle from the quail pen going down. It was an upward shot, correct?
You cannot lead the witness, though I've heard no objections to it.
I haven't heard any objections either, Your Honor.
Well, court is objecting. You cannot lead the witness.
Okay. I know that a bunch of you are mad at me, and that's fine. You're allowed to be. I'm giving you my analysis as a trial attorney who's tried several cases, knows how these questions should be asked and how the trial course of a trial should go. And you can reach whatever conclusions you want about that witness. We can disagree. I'm fine with that. Just please be respectful to those in the chat. That's fine. Here's the interesting thing about this right here. This is the first time the court has interjected. The first time the court has interjected to cut someone off and say that you cannot lead the witness without an objection pending. There has been leading left, right, and center by Creighton Waters, by Mr. Meter, by the defense, by any one of these attorneys. Leading has occurred throughout this trial, and it has been strategic in whether to object or not object. When the court interjects and objects and rewrites the questions being asked or rewrites the direction of an examination, the court needs to be even-handed. I've made the comment that as long as judges are consistent in their rulings, it allows the attorneys to navigate that court fairly. The judge needs to be consistent. This is one of the first times that I can actually say the judge was inconsistent, has been inconsistent in how he has ruled defense versus prosecution on an evidentiary objection. This is inconsistent. When Creighton Waters was doing direct examination and putting conclusions in the statements of every single person there, he did. I was critical of that. When Dick Harpootlian is making all of these leading arguments, he is completely improper in making these arguments. This is his direct. This is his redirect. He is not allowed to lead like that. However, the onus is on the prosecution to object. When the court intervenes and puts a thumb on the scale of how the evidence comes in, that can create a problem. This is the first time that I have observed this judge very noticeably being inconsistent in how he has ruled in weighing evidentiary objections. And it was a bit of it kind of caught me off guard when the judge cut him off. I had to rewind it a couple of times. You shouldn't be doing that as a court. You have to rule consistently. And then people are asking the question, I'm not sorry, Bridget, if you feel that way. Yes. I think this played into it. And I think the early morning antics played into it. So attorneys and judges are people. And there's only so much that they can really separate that. The judge has been frustrated throughout the entire trial. When you have a judge that comes into court and prior to entering the courtroom, they had woken up and seen a tweet that was from one of the defense counsel in front of them, they're frustrated. And they have to do a lot to take that out of their mind before they take the bench. When you have a judge that's sitting there and watches a defense attorney point a firearm and maybe doesn't see the prosecutor that's doing the thing behind the table, but when you have an attorney that makes that joke tempting, the judge is frustrated. But they have to disconnect from that. So this is one where I think the judge kind of did step over the bounds a little bit. And Poot makes the comment right back and says, I didn't hear an objection either, Your Honor. That's a problem. That's a problem. So I hope it's a problem that doesn't continue on. I really do. Because I would hate to see these rulings start just going haywire. It's going to drive me wild. So that's essentially where we end with the conclusion of this particular witness. This witness is off the stand. We will lead to the beginning. Vanessa, will this lead to a mistrial? No, not with this. Not during direct, because here's the thing. Mr. Harpootlian had the chance to go and reframe his question to ask the question the proper way that wasn't leading. I have no problem with that. It's not going to lead to a mistrial. If it continues or if it gets worse, yes, it can. So that's kind of where we are there. People have a lot of opinions. I am just trying to be a devil's advocate so that you guys, maybe a poor choice of word, so that you guys can look at the information that's coming in and view the information as a whole. This is something that's relatively common after the prosecution or the plaintiff rest their case. They rest their case. A logical conclusion is formed in the mind of a juror or a court observer, and then the defense or the other side starts putting on their case, and you are resistant to hearing that interpretation of the evidence. I think the plaintiffs or the state did a great job with their timeline witness. I still had questions. The shotgun analysis with Paul makes it pretty clear that I think the state had it right there. I think that was pretty correct, except for that trajectory of that first shot, which they didn't really testify to today. We'll just have to see where this case goes because it's pretty wild. Okay, let's catch up on some super chats and then we'll get you guys out of here so you can go about your evening, enjoy your time. And yeah, so let's see. Catching up, Kristen Cusick, thank you very much. Thanks for the coverage. Depending on these recaps, since I'm busy with all the things during trial, hubby and I have a date, so I'll be replay crew. Replay crew is loved. Please hit the like button when you are watching. That's fantastic. Thank you. Nick Loss, thank you. TIL, that I am the same height and roughly the same weight as Alex Murdaugh was at the time of the murders. Interesting. The neurodivergent counselor, thank you very much. Gotta love Mardi Gras because it let me watch the whole thing today and not rush to play catch up. Wonderful. I'm glad you're able to watch. Gamer Ducko, it'll be great in 20 years from now when you, Ian, and Scott cover this in Trials of the Century. I hope not. I can't watch this one again. Ryan YYC, thank you. Family law cases usually under gag order anyway. No, they're not. You can testify. You just can't talk about testimony kids give. Nancy Chadwick, thank you. Why did Buster not know about the replacement gun? AM had it. Check out Dr. John, forensic psychologist on YouTube, Break This Family Down. That's interesting. I might check that out. Buster didn't know a lot of things. He didn't know his dad's birthday. I don't know that I read very much one way or the other into Buster's testimony, other than I just don't know that I would have called him. KC Cat, it's called Legal Pad, Rob. I think it's called Trial Pad. That's one of them. There's another one, though. Rose Lala, does anyone else think Rogan was the shooter? I do. Interesting. It's me, Josie81. I think just having Buster on the stand made it look like he supported his dad. Maybe that's all they were going for with him. And if that was the goal, then that was the goal. I didn't see that anyone gained a lot in one direction or the other with him. Kelly D, the witness was credible and very qualified. I'm going to leave that to you guys to assess. Stina G, Rob, the lady who crocheted Bub and his children, also did Judge Newman Creighton. They're all good. I love seeing the talent. Kelly D, thank you. The state experts had a 5-day training seminars. This witness was totally in scope. It was all about science. Some weren't willing to listen to it. I don't agree. The prosecutor was childish. You guys can disagree. And it's interesting. The way that you guys are viewing this is very similar to how a juror might view it. The defense only has to flip one juror to get a mistrial. They only have to have one juror believe that was reasonable. Luck VNO. Paul lured to the kennels by R. Gibson to check on perfectly fine dog. Killer waiting. Didn't expect parents waiting for them to leave, but only Alex did. I don't know. If that's a possibility that you have put into your mind based on what you've seen in this trial, then I cannot tell you that you are wrong. I can't tell any juror that reaches that conclusion that they're wrong. You're dealing with the evidence you're being given. Jennifer Johnson, this was a trick to put 2 shooters, not one, in jury's head. I don't know if it was a trick or not. I was just curious about the trajectories. Mary Coppola, on all the exhibits, they say forensic engineers because they do reconstructions. That's the term for forensic. They basically do backwards analysis, like they look back and look at the cause of something. Tina L, bad Poot. You always assume a firearm could be loaded and treated as such. Absolutely. Pointing it at the state attorney and saying tempting is all kinds of wrong. Yes. That should have never been done. He has pointed the gun towards the gallery on several occasions. He has been way loose in how he's handled that firearm in that courtroom. I have not been a fan of any of that behavior at all. AZ Farrell, thank you. Southern folks, my whole family's there. They think that this is perfectly normal, the good old boys. And that's the thing. We're viewing this from outside of that community. We don't know. Tiffany Bernier, thank you. His hands aren't up as a target. They're up in the defense. That's how I'd react, reasonable or not. That's one way to read it. I just saw it. This is the first time I saw it. I still think that Dick Harpootlian was, you don't point the gun at people. I'm sorry. 9-inch nails gal. What is with the poor safety, leaving them laying around on the hunting property, aiming them at people? Safety, damn it. Safety. That's the problem, is you have a lot of people watching this trial. That's the other part about it. You have a lot of people watching this trial. Kurt, no, you haven't. I'm still catching up, buddy. Brian Alamans, thank you. Say apical meristem. Yes, Rob, that is loblolly pine. Yes, it is. Ryan Men YYC, thank you. They're just showing that they did more thorough analysis than the state. It's possible. Marty Hufford, thank you. Have I missed any testimony that addresses AM's rifle shooting proficiency? Is he considered a marksman? Did he do a lot of hunting? I know that people have testified he did a lot of hunting. I don't know whether he was proficient. Just because you shoot a gun doesn't mean you're good at it. So I don't know. We're left to basically reach that conclusion. Inagata Danita, thank you. Thanks for the explanation about the type of pine tree and its lack of low branches that really explained his testimony. Thank you. AZ Farrell, this prosecutor gets so angry soon. He got really angry. The page flipping. Dude, you found You're not going to find the question magically when you flip through the same set of papers 19 times. You're doing that because you're frustrated. Interesting. Very frustrating. Kelly, thank you. I agree. The triangulation acoustics presented possible doubt. The position of the shooter raised the possibility of more than one shooter. It made me think the shooter was experienced and sober. I don't know. This is where you guys come in. I'm watching this and I'm more curious in the trial than what the facts are telling me in this trial. But I can't disagree with some of his analysis. I thought he got to speculation at a couple places, and they were asking him to opine beyond the scope of his expertise. But then again, who do I blame there? The scope of his expertise wasn't really laid out and clarified by either party before he started testifying. He just had this general scope of expertise in physics. That's pretty big. That's a broad category. Bop it. Thank you very much. Question. Buckshot equals 9 pellets. Some hit PM, others did not. If one pellet was used to determine the angle of the gun location of the shooter, what does the trajectory of the other 8 pellets say? Like I said, I don't know that evidence gave us anything to add. The only thing that I thought was interesting was when the questions were being asked to try and discredit the findings or conclusion of that pellet. I just thought there were some dishonest questions in there. And you've seen the defense do it with every cross-examination, trying to bring in out-of-scope questions to have this expert answer it. It's trial tactics. I'm just trying to clarify. C minor OP67 agree, RE tree growth. On EM's chat, you said carved names would be higher. And I was like, no, they don't. They're not higher. No, carved names do not go higher. They stay at that height. Jazdia, thank you. My husband is an engineer. I bought him a t-shirt that says, I'm an engineer. For argument's sake, assume that I'm always right. I know a lot of engineers that are like that. Lots of them. They're tough to convince. The last thing you want on a jury is a ton of engineers, because if you give them something that sticks in their brain, they are not going to let it go. You better have an explanation for it. So, AZ Farrell, lawyer searching for a comeback, already sounds angry. There was a lot of anger today. Kentucky Gastineau, my husband has 3 degrees in engineering. The math he has learned, knowing the laws of physics, etc., allows him to analyze and solve problems. That's what I thought this witness was doing. He was reverse engineering the state's conclusions based on their evidence. That's what I thought they were doing. I didn't see anything wrong with a lot of the testimony. Lynn, GMB, why are they reviewing as if Alex threw the cell phone? They did that analysis. I didn't have time to cover it today. You guys can go check it out. I wonder if Peter might do it, so go check him out. But that testimony is on the web. Daisy May, having watched many trials, I find this one particularly strange when it comes to the lack of objections by both sides starting day one. I agree. And the way that the judge corrects that, I think, is to bring them sidebar. I don't really care for the judge ruling in and weighing in on one side, but not the other. It gives a very interesting look to the jury. And I don't think that was the right call. C minor OP 67, why not let it in? Prosecution is proving the absurdity. Those two were interesting to watch in the well. Uncivil, witness has big bleep energy. I think that they both were trying to raise the prospect that their Schwartz was bigger than the other one. It was really pretty interesting, but the witness didn't get angry. I don't think he got combative. That was probably about as combative as he got. I think the same can't be said for the prosecutor. And honestly, you've seen other attorneys do the same thing. Daisy May's cross makes him look extremely inexperienced and lacking. I could read this either way. His cross, meaning the cross-examination questions asked by the attorney, make the attorney look inexperienced, or the impact of those questions on this witness that made him look inexperienced to you. You can perceive that in either direction, I think, based on what you saw. Leslie P., solidarity for the short adults and those borderline like me. I know a lot of people 5'2", 5'1", 5 feet, 4'9", 4'11", all the above. I don't understand why we were going with there. AMI Jax, is badgering the witness a real thing, or am I watching too much Law and Order, or both? This attorney came close with not letting him answer. Poot has done it previously with not letting them answer. It's when you cut them off and when you ask them questions over and over and over again. multiple compound questions that are improper in form. Asking one question, then they start asking another one. When you start doing that repeatedly, that is badgering. Dealy Moo. Hey, Rob, I sent you something. You should be getting it Thursday. Thanks for all you do. P.S. I'm barely 5 feet and I feel very attacked today. A lot of people had opinions on that. Thank you, Dealy Moo. I'll check that out. Thank you. New Zealand Butterfly Girl. Heather, thank you very much. The engineering witness said he created the PowerPoint presentation the day before he testified, and he does this all the time. Does that mean he doesn't give a copy to the prosecution? Is that allowed and or normal tactic? I mentioned this earlier in the stream, Heather, and I'm glad that you're here asking the question because it's a good way to recap it. One of the things that both attorneys on both sides, I guarantee you that the defense has done this, the prosecution has done this with their experts. This just happens with experts. You don't give them the copy of the report because you haven't created it yet, and it's not finalized yet. It happens all the time. They're supposed to give you some of the foundation of their opinions prior to that moment. You're allowed to depose them prior to that moment, but it's not required until it's created. And a lot of people do it. They will wait until the last minute to finish their report, and they'll bring it into court that day. They do it for the state. They do it for the defense. Is it fair? Nope. Do both sides do it? Yep. And they both get away with it. It drives everyone crazy. So yeah, it's pretty interesting. Stephanie Coker, thank you very much. So many arguments are over irrelevant evidence: turkey shot versus buckshot, tarp versus raincoat, polo versus Vinnie Vines, fish versus human blood, graph versus timeline. I want to know where all these drugs ended up. I don't think you're alone, Stephanie. I also think that with this case, which is a circumstantial case, the reason we're fighting about things that feel irrelevant is because the state has to prove all of these different circumstances to a reasonable degree of certainty, beyond a reasonable doubt. They have to prove those circumstances which form the foundation for your conclusion of guilt. So that's why we're fighting over a lot of things that seem to be irrelevant. And I think the state, with the last 2 or 3 days of their case, they made a lot of progress there. And I thought this was the defense's case to kind of lose, depending on how much into the weeds they get. So we'll see. Kelly Towels, thank you. By the way, Emily's this Alex Murdaugh and you now. I've avoided grading my students' essays and reading for my grad level Shakespeare class. I make good choices in life. This stuff is really curious. I will say that when I end up watching these trials, I can get a lot of work done until I get to a point where it gets kind of frustrating. When this cross-examination happened, it like perked the ears up to the point where I was having trouble getting work done. So I feel you there, Kelly. AZ Farrell, oh my gosh, my grandma's 5'2", have shot blackout often. I think that other people can reach that conclusion. Lauren L, thank you. My 5'2" behind feels attacked. I was not ready. LOL. A lot of people weren't. Daisy May, thank you very much. Rob, your super chats are making it on screen. They are? I hope they are. Hope you guys are seeing it. Days Mate, sorry, not making it on screen. I've been pulling them up. I hope they're there. I think they're there. So hopefully. Otherwise, I'm just StreamYarding wrong. Sorry. Adrian Angevine, thank you very much. As a 5'1.5" tall woman, I want to know how tall the jury is. All over 6 feet? I think not. Read the room, dude. That comment will backfire on him. I don't know that it will. I just think that you don't want the jury to focus on the part of the question that's not really the relevant part of the question. The relevant part of the question was the height of the shooter. And where did this shooter of this height come from? You know what's funny about asking the question that way? The only thing they hear is you just called the shooter a child. You didn't ask the question of where did this 5'2" person come from? Michelle Salter, thank you very much. I wonder if it's the famous mafia midget during drug gang. I don't know. The entire question was interesting. C minor OP 67. If only everyone would stop pretending to be offended. Witness said shooter was 5'2". Most that height are children or short women are. I'm not saying it's about offense. I'm saying that it's a misstep. I just explained why too. The last thing you want the jury to focus on is the wrong part of the question you asked. Prosecutor made a really great point today, and he made it in the middle of his cross-examination. It was really frustrating. And it was the point where the prosecutor asks the expert, pulls out the tape measure and says, so it'd be this is where the height of the gun was, right? And then the prosecutor kneels right behind where that tape measure was. And in my head, I was going, sit, make the point, make them refute it, then get back up on recross if you need to, but sit. Everything else that you get after that point isn't going a lot of places. And it leads you to make that gaffe, the children part. It was curious to me. It seemed like he wasn't in control. Peggy, thank you very much for the super sticker. Heather, thank you very much. Is the judge allowed to raise objections if the other side hasn't made the objection? Yes, the judge is technically allowed to do that. The judge is allowed because the judge is the ultimate arbiter. If information gets in, even when not objected, if it's too prejudicial, the judge is allowed to control what information gets all the way to the jury. So it's one of those things where I can see where a judge could step in at a certain point of time, but they have to do it consistently. That was the first time. I know that people are saying the judge rules against defense all the time. You've been able to kind of gauge where the judge is going to come down on a lot of these issues. He is very much in the camp of allowing more information than less information. That is a consistent ruling I can work with, whether I'm defense counsel or prosecutor. It's when he treats one side differently in the course of their actual questioning that can kind of bother me. Virginia Tracy, thank you very much. As an adult woman, 69 years old, I find the man's statement insulting. Also, please remember that midget is a slur. Don't use it. You put it in your super chat. I'm sorry. Little person, small person. I didn't mean to offend anybody. I'm trying to do this properly by reading. So I apologize. Don't mean to offend anyone under that height. Like I said, my sister is very, very short. Her husband is very, very short. I love them very dearly. I could probably rest my arm on top of my sister's head and her husband's head. I love them. They're fantastic. I don't mean to make fun of anybody. Shannon 7, all in all, I still have reasonable doubts. So right now, not guilty in my opinion. Interesting to hear differences in opinion between the streams. Thank you for covering the trial. Thank you. I think the chat has been very interesting dynamic to watch. Watching people make conclusions in one direction or the other. I've been just very curious watching all of these differing thoughts. And this is where you go when you have trials. It's very interesting. And it tells you what weighs strong with potential jurors. WW, one of the men I graduated at high school was never grew over 5 feet. He's 43. Fair point. So anyways, okay, here we go. That is it for this evening. That's the recap. Hopefully you guys enjoyed it. If you are still here watching, thank you very much for being here. If you wouldn't mind hitting the like button on your way out. Keep an open mind. We're going into the last day of this trial, or not last day, the final stretch of this trial, the defense's case in chief. Please keep an open mind as you hear the evidence. Please be respectful of one another. We can disagree on a lot of things. That's fine. We're allowed to, as long as you do it respectfully. One last one here. Crumfelt, thank you. I believe drug gang issue that went bad. If the defense will show that Eddie was connected with Mexican cartel, 5'2" shooter makes sense. As defense criminal attorney in North Carolina, I can attest Mexican cartel runs pill distribution in this area. Interesting observation. I don't know. That's a very interesting observation, though. Karen Hamrick, thank you very much. Relating to the family law, a close friend worked for a country club in Northern Virginia. She knew the drama about high-profile divorces early. As you know, country club memberships are fought over. She'd tell us, but not name names. Yeah. We don't name names. It's fine. You can fight over this stuff. You don't name names. I agree with that. Yeah. I tell you guys about some of my cases without getting into the weeds or details about the case itself. IX Savage, Skip, XL, thank you. People need to stop being offended at a whim and listen to the words actually being spoken. I don't disagree with you. I am more focused on the information being provided. I just thought that information can get lost pretty quickly. So thank you all very much for being here. I very much appreciate you. I'm going to send you guys on your merry way. If you are sticking around, you will be redirected over into Lawyer You Know. Give him a wave for me. I will catch you guys on the next recap, and I'll see you then.